Hello students, welcome to Legacy IAS Academy. In today's video, we are going to discuss about the recent ruling of Supreme Court that has come related to the Hindu Marriage Act and more specifically related to the maintenance of the wife by the husband if they have separated or divorced. Now in this context, the Supreme Court has clearly stated that as far as the proceedings are concerned, two different things are there. First of all is the restitution of conjugal rights. That is a decree which is passed by court sometime to mandate that the husband and wife should live together. And the second is related to the maintenance. That is, if both husband and wife have separated, the wife is eligible to have certain amount of allowances from the husband to take care of herself. Now, in this context, Supreme Court has noted that both of these issues are altogether independent and are not directly or even indirectly connected to each other. So whenever a judgment is being passed related to the marriage, divorce or separation of any spouse, these two topics or issues should be dealt separately. And here a husband, he has basically, the Supreme Court has stated that husband must continue to pay maintenance to his wife even if she refuses to comply with a decree for the restitution of conjugal right. In simple term, restitution of conjugal right means that even if the wife is given the order by the court that she should go and live with her husband, and even if she does not comply with that order, in that case also husband has to pay allowances or maintenance allowance to his wife. So this is the overall judgment that has come from the Supreme Court. Now we talk about this particular term, that is the restitution of conjugal right. It is mentioned in the section 9 of the HMA, that is the Hindu Marriage Act 1955. And under this particular section, it has been clearly stated that if a wife or husband, we have to keep in mind that this is not specifically related to the wife or husband, it is gender neutral in nature. So if a husband or wife has, without reasonable excuse, now that is the point that had to be noted, that without reasonable excuse, if withdrawn from the society of the other, the aggrieved party may petition the district court for the restitution of conjugal rights, and the court may then issue a decree granting the application. And in this case, in year 1983, a landmark judgment came from the Andhra Pradesh High Court, where AP High Court has struck down this particular section of the Hindu Marriage Act, and it has even questioned that whether such kind of section has any role or significance in the modern society, where we are talking about the personal freedom, we are talking about the right to privacy. And on the other hand, when the next year the matter was sent to the Supreme Court, it has then reserved the, basically opposed this particular viewpoint of Andhra Pradesh High Court, and it has said that this section 9 is basically important because it is an aid to the prevention of breakup of the marriage. Basically, it is a way through which a family can be preserved, that can be made up of husband, wife and the children. So Andhra Pradesh High Court had given a judgment, but that was reversed by the Supreme Court. So this is overall, we can understand the stand of judiciary today on the restitution of the conjugal right. Now, if we take a look at the present case, what this present case was all about. So actually in the year 2015, just after 1 year of marriage, the wife in this particular case had separated from husband and was living separately. In the July 2018, then the husband has filed a suit for the restitution of conjugal right, as we have discussed under section 9 of the Hindu Marriage Act. Then in the August 2019, under the section 125 of the CRPC, that is Criminal Procedure Code, that earlier was in practice 1973, then court has said that husband has to provide monthly maintenance allowance to the wife. Now you have to understand that even though in this case the court has given the order and it has given the order of restitution of conjugal right, the wife was not living with the husband, and then she has said that she cannot live with her husband because by husband and her family, she is being ill treated and she has to suffer a lot of mental agony. Thus, in April 2022, the court has passed the judgment for the restitution of conjugal right. But this was something that was not accepted and agreed upon by the wife. Then in February 2022, as I told you before, the court has given the verdict that husband has to pay a monthly allowance. In this case, it was rupees 10,000 per month. So in August 2023, the Jharkhand High Court, again, it took a cognizance of section 125 of the Criminal Procedure Code and says that this monthly allowance husband should only give if a wife is living with her husband. So a wife shall not be entitled to maintenance if without any sufficient reason she refuses to live with her husband. And then the particular decision of Jharkhand High Court was actually challenged by the woman in the Supreme Court, and is related to this. The current verdict that we have talked about has come from the Supreme Court. Now the question comes that why did Supreme Court has ruled in her favor in this case? So we can trace it back to another case that was in that came in year 2017 in front of Tripura High Court. Tripura, as you know, is northeastern state. So in Tripura High Court, now in this Tripura High Court case, what court has observed that the mere passing of a decree for restitution of conjugal right and the wife's refusal is not sufficient for the court to disqualify her from the receiving maintenance. And it is the same judgment of this particular High Court that has been upheld by the Supreme Court as well. Not only that, the Supreme Court also has said that for any such matters, we can also take decision on the case by case basis by looking and examining the merit of the case. And it has said that in the present case, the Jharkhand High Court, as it has given the verdict that the husband had no what you can say compulsion to pay the monthly maintenance allowance to wife, it had overlooked a certain crucial factors. And what are these crucial factors? It is those crucial factors which might have prevented the wife from trusting and living with her husband. So wife just cause not to return to her matrimonial home. So just cause, what was the just cause in this case? That has been overlooked by the Jharkhand High Court, and that is why Supreme Court has reversed the judgment of the Jharkhand High Court. Now the question comes that as far as the legality on the conjugal right or legal debate on conjugal right are concerned, where do we stand today? Now as I told you in the beginning also, that two verdicts are there. One was AP High Court verdict in 1983, where it has questioned the section 9 of HMA and its validity in the modern context. And on the other hand, the next following you have Supreme Court's stand, where it has said that section 9 helps in preserving the integrity of the entire family. So that is why it is essential. Second is also the question has been raised by some students of Gujarat National Law University, where they have filed a petition and said that the section 9 of the Hindu Marriage Act is something that can be considered as a violative of the fundamental rights guaranteed under the constitution to us. For example, the section 9, it is based on the patriarchal conception of the woman as property. That is why she is forced to live with her husband, and it entrenches the gender stereotypes as well. And also it has said that the provision also violated the right to privacy, which has been upheld by the earlier judgments of Supreme Court also. For example, you talk about the Justice K. Puttaswamy judgment. So there it has been stated the right to be let alone is also comes under the umbrella of right to privacy. So this is something that is being compromised by the section 9 of HMA, and that is why the petitioners have asked the court to strike it down, as was done by the Andhra Pradesh High Court. Now as far as the central government's response is concerned, so in 2023 in terms of answering the PIL and the Supreme Court's question, it has said the provision is gender neutral. It does not have any kind of what you can say discriminatory attitude either toward the wife or toward husband. It applies equally on both, and that is why the point that was raised by the Gujarat National University that it is kind of gender, it entrenches gender stereotype is not valid in this case. And also it gave couple a relatively soft legal remedy to resolve the differences that might arise due to normal wear and tear of matrimonial life. However, as far as the substantive hearing in this particular case is concerned, it is yet to begin. So we'll have to wait and watch and see that what finally or ultimately Supreme Court decides, whether section 9 will be upheld, will remain part of HMA, or whether it would be struck down. So that is all for this particular video. Thank you very much.